Good morning. Good morning, everybody. It's 11 o'clock and we've been a little bit stalling here for a moment, but we're on now. So let me begin and just say that my name's Eric Story, and this is I'm from the Edmonton Pride Seniors Group. And thank you all for attending our weekly Aging with Pride sessions. And also thank you to our partners, SAGE and the Pride Center of Edmonton. Before I introduce our speaker today, I'd like to acknowledge that we're located on Treaty 6 territory and respect the histories, languages and cultures of First Nations, Métis, Inuit, and all First People of Canada, whose presence continues to enrich our lives and teach us valuable lessons. Two housekeeping items. First, I must let you know that this session will be recorded for future use on our YouTube channel. If you don't wish to have your image recorded, please close your video feed. Secondly, I remind you of the code of conduct outlined in your Zoom invitation and underscore a couple of points. Please respect the speaker by remaining muted during the talk. We will unmute you for the Q&A. Be mindful of our time limitations and keep your questions and comments as brief as possible so that everybody can participate. Everyone who wishes to speak will be given an opportunity to ask a question before individuals who have already spoken will be asked to speak again. And please respect the confidentiality of and personal information. And now, let me think just one other thing. I'd just like to introduce Erin. Erin's primary practice focus is in the areas of wills, estates, incapacity, and disability. She has extensive experience handling estate and guardianship and trusteeship litigation, including contested wills, capacity, and dependency issues, and actions relating to estate accounting. Erin provides practical advice considering the risks and benefits to her client at all stages of litigation. Additionally, Erin drafts estate planning documents, including wills, powers of attorney, and personal directives, and handles probate and estate administration matters, including complex and contested administration. She has appeared before all levels of the Alberta courts in trial, appeal, and interlocutory matters before professional and administrative tribunals on disciplinary and appeal matters. Erin also has experience in the dispute resolution process, including private mediations and judicial dispute resolution. Erin, that is quite an impressive resume. Thank you so much for agreeing to speak with us today. I'll turn it over to you now.
Well, thank you for tolerating the length of that introduction. So to shorten things up, my name is Erin Lafuente. I am a partner at Edmonton, and I practice in our estate group. So as was indicated, I do a little of everything in this area, starting from what we're going to talk about today, which is estate planning, and how we hopefully have you and your loved ones not be involved in the other part of my practice, which is the estate litigation. You know, how do we avoid those fights before they're going to start? And so that's what we're going to talk about today. We're going to talk about trying to keep control of the process for yourself. You make the decisions as powerfully as you can so that your wishes are observed when you may pass, or prior to that when you may lose capacity. So I'm going to share my screen. Oh, I can't, so hopefully the host will allow me to do that.
Just 1 second.
Yeah, no problem. So while I'm waiting for that, I'll just say, so I was called to the bar in 2002, so I'm coming up on 20 years this next month, actually. In May will be 20 years. I've been a partner at Denton's since 2014, and I was a partner at another Alberta law firm prior to that. I also teach with my partner the Wills and Estates class at the U of A. So I really just focus on this, and I'm pretty passionate about the kinds of planning that we can do to make things easier for our families. Okay, perfect. I can share my screen now. So let's see, find the right screen. There we go. Go back to the beginning. All right, can you guys see that now? Great. And so I want to say, questions are always welcome. Sounds like we're going to have those at the end, and that's great. If your question is really specific and you're uncomfortable asking the question on video, not a problem to shoot me an email. My email will be at the end, and I'm happy to answer some questions by phone or email later. And sometimes I think it's best if your question is a little bit more detailed than a group setting allows for you to do that. Okay. All right. So what are we going to talk about today? Essentially, we want to talk about what kind of planning do we need for the future from a legal perspective. And there are two times that we want to do that we're really looking at. The first is during illness. It's not what we think about when we call up a lawyer and say, I want to do my estate planning. We're thinking about a will. It's the obvious one. It's the one we think of. But I'm going to tell you that planning for your incapacity is just as, if not more important. And that's because you're still here. You may have lost the ability to participate in the process of decision making, but you're here. And so we want to make sure that your wishes are respected. So during a period of incapacity for illness, if you have dementia or you get in an accident and you lose consciousness for a period of time, that's when we have two kinds of documents we're looking to get. One is an enduring power of attorney, and that's going to be done to have someone make financial decisions on your behalf. And the other is a personal directive, and that relates to personal, non-financial decisions. And it is an incredibly important document that I think is not given enough importance when people think about what they need to do. Because that document says, where am I going to live? With whom am I going to associate? What kinds of healthcare options do I want to be pursued or not pursued? What about things like life support? So it's a really important document. And then, of course, we do have the other planning for after we pass, and that is done through doing a will. The importance of all of this and the importance of today is that I'm sure we've all learned, especially in the last few years, we don't know when we're going to need this planning, right? Sometimes things happen suddenly. I'm sure many of you are just like me. Naturally, we procrastinate. That is just human nature. But this is one of those areas where you can't procrastinate because you don't know when you're going to need it. And the opportunity to make decisions for you will be lost if we don't take advantage of it when we do have capacity. Really important. And when I was asked to do this presentation, one question that was sent my way was, sometimes we have a family that we choose versus the family that we were born into. Okay. And if we want to make sure that we respect the relationships with those that we've chosen and who've chosen us and who've supported us, then we need to make sure that we do these documents, because then you have the power to choose. The law presumes that the family we're born with are the first people who are going to have the rights to make certain decisions about us when we lose the ability to make those decisions. But if we get ahead of the game and we set our plan in motion, we meet with a lawyer and we say, I choose John. John doesn't need to be related to me. John can be a person who I trust. I can pick John. And then John gets to tell people who may otherwise try to bully their way in, no, I know what Erin wanted, and I'm the decision maker. So it's very powerful. Choose your plan, choose who's going to participate in your decision making. And that is the purpose of doing these documents. We like to be dramatic at Denton's. So we want to scare you into thinking you have to get these documents done by showing these happy families that you really want to have versus families in strife. The reality is estates are inherently confrontational beasts. If we don't plan ahead, we can unfortunately set our families up for more of this versus a really happy looking family here. And which do we prefer? We often at Denton's say, one of the goals of doing really good estate planning is, how do we have your family still want to have Christmas together the year after you die? And it sounds like a small thing, but unfortunately in estates, it's not. It's something that can really be set up well or not set up well at all. All right, so as we discussed, Planning for incapacity is very important. We need to plan in the event of a sudden illness. We need to preserve our assets. You may have a business that needs to have a succession plan. We need to figure out what we are going to do with those assets and how they're going to be taken care of. One thing that surprises people is that in law, we don't have a natural ability to look after our loved ones' finances. I'm sure you've all experienced, everything nowadays is about privacy. If I wanted to call and ask what my husband's, if the power bill's in his name and I want to figure out what we owe, I can't just phone up and say, hey, can you tell me what we owe? Because I'm not going to be given that information. Privacy laws are going to dictate that I can't have that information. But it's obviously important that I do. So what we want to do is make sure that we have a power of attorney in place that allows me to get that information for my loved one. What if we need to pay a mortgage? How are we going to do that? How are we going to access the funds to pay a mortgage if someone has become suddenly ill? What gives us that authority? And the reality is that authority comes through a power of attorney. Okay, so that's the document that we want to do. An enduring power of attorney is a document that says, I, Erin, appoint Jan to be my attorney. Jan doesn't have to be a lawyer. Yes, Jan, thank you for accepting. Jan doesn't have to be a lawyer. The word attorney, there's a bit of a misnomer. It just means decision maker, okay? And what it does is it says, okay, I'm picking Jan. Now that's good because I've been given the power to decide who I want. I want to pick somebody, obviously, that I trust, okay? This is a big power. This is essentially like handing someone your wallet with all your passwords. So you want to pick someone you could trust. I like to tell people here, and this applies to the personal directive and the will as well, when you're making these appointments, these are not gifts or honors you're bestowing upon people. These are jobs. They're significant jobs with a lot of responsibility. So you want to pick people that you know are capable of doing those jobs. I like to pick people who are good at making decisions. Okay, maybe not people who are indecisive. People who are good communicators can be best in these roles because we want someone who can communicate with the other people without creating more trouble. What we should not do is say, well, I have to pick my oldest child, for example. Lots of people default to that, but that doesn't mean that that person is the best qualified. Sometimes it's not a family member at all. You need to think about who would be good. Who could you give your wallet to and know that that person was going to use your funds to protect you? Okay. Now, there's two kinds of powers of attorney. One is immediate, and it's really obvious. As soon as I sign it, it takes effect. We don't use that as often. It would be used primarily if I was about to go on a vacation, I was going to be gone for a long period of time, maybe my property's up for sale, and I want somebody to have the ability to sign those documents on my behalf, I might do an immediate power of attorney. We also recommend them often if people have had a diagnosis, a cancer diagnosis, or perhaps a diagnosis that affects the mind, something like dementia, where we're going to decline over time, and I might need a little more assistance as time goes, but I haven't completely lost capacity. I might want to have an immediate power of attorney that's in place as soon as I might need a little bit of assistance. But for the majority of people, we don't, I don't sign one now and says, okay, my husband, you can make those decisions for me tomorrow. That doesn't make sense, because I want to be still the one to make decisions. I'm rather known to be rather bossy. So I don't think I want to give up that power. So what I need is a springing power of attorney. And I like to describe those as the superhero of powers of attorney. It sits in the phone booth and waits until you need it. And as soon as you need it, it springs out with its cape on and jumps into action. Okay. And the key with that one is it will say in the document, this does not take effect until. Okay, and that until will usually be, two physicians indicating that I have lost capacity. The beauty about the document is that I'm signing it today. I know what I want. I know who I trust, and I get to pick. Okay, I also get to give some direction. So I might have some property that I don't want to have sold, something that I really want to go to my kids or my nieces and nephews, stay in the family, something like that. And you can indicate that in your power of attorney. But generally, it's a good idea to be a little bit more broad in that power, because we don't have a crystal ball. I don't know when it's going to be needed. I don't know what power that person's going to need. So I want to just basically empower them to do what is necessary. Okay, so if you're thinking about getting your planning done for a power of attorney, we're looking at who would I pick? Then perhaps who would be an alternate if that person can't do it? And do I need help now, or do I need help sometime in the future? And those are the kinds of questions that should be kind of in your head as you're thinking about preparing this document. Now, the other side of planning ahead for incapacity is the personal directive. Now, this one I'm pretty passionate about. It's a really important document to have. And it can be done really well, or it can be done a little too generically. So this is one where there is a form you can get off a government website that will allow you to appoint an agent. So in this document, instead of an attorney, you have someone you're going to call your agent. And the one that's off the government website, it works. There's nothing wrong with it. But what it does is it basically just says, you know, Alvin has power to make decisions about me, my healthcare, where I'm going to live, etc. But it doesn't really tell Alvin what I want. And why I think this is so important is that at this time, this one is always springing. Okay, a personal directive always takes effect when I lose capacity. When I need this, I'm probably not going to have the ability to speak for myself. Okay, my decision making has been lost. So when I do have the ability to make those decisions about life support, about organ donation, about whether I'm comfortable with a nursing home or I'd rather live at home and have my funds spent to keep me comfortable at home, I should say that when I have that authority. So I think it is an incredible gift to yourself to do a good job of a personal directive. Okay. And when I say good job, that means, you know, as a lawyer, I'm not just grabbing a precedent off the top of my shelf and saying, oh, here, Michael, sign this. I want to have a discussion with you, Michael, to say, okay, what makes sense? You know, what do you think about life support? And sometimes that can be surprising, even for couples. I once met a couple who came in, and one of them was like, oh, of course I want to be on life support. That makes sense. And the other was appalled and said, what are you talking about? You know, we have to, you know, just trust the doctors. There's nothing to be done. I don't want to be kept alive artificially. And I was a little uncomfortable for a few minutes sitting in that conversation. But what we learned in that conversation was that they each had different values. It was okay, because you can do that for your partner. You just have to know what your partner wants. So this is all about empowering yourself by putting your wishes down on paper. So you do a good job. You should look at your personal directive and be able to read it and say, this speaks for me. If I don't have a chance to speak for myself later, this document's going to do it for me. Okay. Now, this is also an incredible gift to your family. Okay. I recently had someone in my life pass, and we had to deal with life support issues. And it was really powerful to know what she wanted, right? Because we didn't have to second guess ourselves whether we were doing it right. And I've been involved in legal situations where the opposite has happened, where half the family thinks life support is necessary and half the family thinks life support shouldn't be used. And that is an impossible argument to be involved in, because nobody's wrong. Nobody's, you know, trying to cause a trouble. But how can you back down if you think dad wants to be on life support, or you think dad doesn't want to be on life support? And I always think about this in terms of myself. And I think, you know, if it was my husband making the decisions, I know he would know what I would want. But if something happened to the two of us, and my brother had to step in, I cannot imagine the stress that it would be upon him to make a decision whether or not to keep me on life support, because I have kids, right? And he would be thinking, I'm making this decision and look how I'm affecting my niece and my nephew. But if he can look at that and said, this is not uncle making the decision, guys. This is what mom wants. Here, we can read it on paper. Then everyone's going to be more comfortable with the decisions that need to be made. So it is a powerful gift to yourself in empowering your own decision making. And it is a powerful gift to your family in letting them know unequivocally what you want. It is important to be thorough. It is important that you read what's been written before you sign it and make sure it speaks to you, that you and your partner aren't given the exact same document if you don't have the same wishes. There is a lot that can be dealt with it. We do cover medical assistance in dying in our precedent, but I want to be clear that that's not something that's yet allowable in law for your agent to make that decision for you once you've lost capacity. The law at this point in Canada still requires that you make the decision when you're capable, but we include it for two reasons. One is that we know that the laws will evolve over time. Whether they'll ever evolve to allow an agent to make that decision, I don't know, but I think it's also a powerful way to further give information to your agent about what your wishes and values are. It might help make other decisions to know, for example, you would or wouldn't support investigating the idea of medical assistance in dying if you had certain conditions. Okay, so I'm hoping you're going to finish today and think, okay, I really need to make sure I have a power of attorney and a personal directive. And if you have one, you're going to read them and make sure that they're okay. But the reality is, as I say, we procrastinate. So what happens when we can't get one done? What if someone loses capacity before we get that done? The reality is that there is an act, it's called the Adult Guardianship and Trusteeship Act, and it allows someone to be appointed on your behalf, a trustee to make money decisions, and a guardian to make personal decisions. It's a good process. I do it very often, but it is not my favorite outcome. And the reason for that is that instead of paying a small amount of money to get power of attorney, a personal directive, and a will done, now you're bringing an application to the court, and that's going to cost a few thousands of dollars. But really, the bigger key is we've lost control. Okay, so instead of me picking my husband and my brother, now I've got anybody who wants can go and apply and say it should be them, and that's where I get involved in those really ugly litigation files about who's going to take care of mom and which of this. And if the siblings don't get along, you can imagine that that is not very pretty. And mom no longer has the ability to say really who she prefers. So it's an increased cost. It's also an invasion of privacy. So it's important to understand that if we have a power of attorney, so if something happened to me today, my husband or my brother could take over under my power of attorney. Okay, and they could do that just by bringing a document to the bank. If I don't have that, now say my husband has to go apply to the court to get a court order, all of my personal information, including how much money I have in the bank, including my medical condition, all has to be filed in the courthouse, and it is a matter of public record. So it's an invasion of my privacy. It's also, though, a significant invasion in the privacy of the person who's going to apply to be your attorney or your trustee or guardian. So let's assume it's my brother. My brother would have to submit to a criminal record check, a credit check, and a personal reference check. All very important things to have, but he's the person I would have picked if I'd had the documents in the first place. But he has to go through all those things. So now his personal information has to go before a court. And I can't tell you how many family members I've met who want to help, but who are a little sheepish that maybe their credit's not the best, or lots of people have something that happened in their way in the past. In 1980s, someone had a driving under the influence charge that they've never went and got a pardon for. And I will tell them, don't worry, I can still get you appointed. We'll just go through these hoops. But it adds a lot of stress. So we want to avoid this process. Do a power of attorney, do a personal directive, do a good job of them, and we will avoid this additional cost and loss of control. Really, it's about control. Okay. If you have a guardianship and trusteeship, we've started to talk about this, you lose control of your families in the court system. So it's not advantageous. There is often a concern, though, about if I'm not in the court system, well, what happens if my attorney does something bad and takes my money? The reality is we can always still go to court and address a bad attorney. We can get money brought back in if they spent what they shouldn't have spent. We can address a person who's an agent who hasn't done a good job. The powers are still there, but we're not required to be in the court system, okay? All right, that kind of covers sort of that pre-death planning. Now we have to think about, well, what does the rest of that plan look like? And that's the will. And in this case, we're really looking at what is my plan? What would I like to have happen with my estate? Who is and what is important to me? And how do I protect them? How do I decide who's going to be in charge? And how do I keep my family and loved ones out of court and free of conflict? That's the goal. Now, this is one that I like to tell people, you do this, and the more you have any issues in your family, the more you need to do a will, because the law will create an estate plan for you if you don't have one. You don't have to worry that the government's coming to take your assets. That's not what happens. But we have provisions in our laws that say these people are your next of kin and they will get your estate. And unfortunately, it is black and white. And so that concept we talked about at the beginning about our family of choice versus a biologic family, perhaps a sibling or two that we are close to and one that we're estranged from, you don't get to pick. If you've not done a will, it is a prescribed list of people. I once had an estate that was a surprise. I was acting for two people. They were in a piece of litigation against one of their siblings, really contentious. So two siblings against one. And one of the two people who brought the lawsuit died very suddenly. It had no reason to expect it was going to happen, died and didn't have a will. And the sad thing was, I knew as well as anybody that he would not have wanted the sibling he was suing to be a beneficiary of his estate. But there was no way around it because he had not done a will. So the power to choose who and what we honor by giving a gift in our estate is done through doing a will. Okay. So people will often say, can I go get some of those will kits? Yes, you can. I don't suggest it. And the reason I say that is because our laws are very, generous isn't the right word, but they are open to interpretation. If I write a word, I need to know what that word means, what it could mean. And you want to get a lawyer who has experience doing this. Don't recommend you get any lawyer. You need to find somebody who does estate planning, because certain words can have certain meanings in one situation and not in another. And if we are imprecise in any way, we're opening ourselves up to litigation about what did Joan really mean when she wrote that. Okay, and we don't want that. So I do recommend that you use a lawyer. Wills kits, one of the concerns I also have with them is that there's very prescribed ways that a will needs to be signed. And we want to make sure that it is signed correctly, because that can impact whether or not it's going to be, upheld. Can I leave a note? I have the best of intentions. You hear the seminar today, you say, I'm going to call, I'm going to make an appointment, I'm going to get my will done, but you know what? I'm going to Mexico tomorrow. What can I do? In Alberta, we do recognize the concept of a holograph will. Okay, that means I can leave a note. The key, though, is understanding that imprecise language tends to cause problems. I will tell you that in 20 years, I don't think I've met a holograph will that didn't cost more money to deal with than if a will had been done right in the first place. So I've never really met a holograph will that I liked. You can do one, but they generally cause a little bit of problem. But one of the big sort of impediments to doing a holograph will is that they have to be 100% in your handwriting. And we don't handwrite very many things anymore. We type a lot. And you couldn't type something out and just sign at the bottom. That would not be a holograph will. It has to be 100% in your handwriting. The other reason it's really important to do a good job of this estate planning, to have a lawyer who has experience doing this and who takes the time to ask you the right questions, is that your plan only works if it matches what your estate is already set up as. So it's important to understand what is part of my will and what isn't. So it's important, for example, to understand that if you and your spouse own everything jointly, the spouse is going to get those assets on death. And if I leave a will that says I want to leave, such and such to my kids, but it's owned jointly with my spouse, it's not going to work. Same as life insurance proceeds or anything that has a beneficiary, we need to know that they're going to go to those beneficiaries. I once did an estate I didn't do the will, luckily, but I did the estate afterwards. And this individual had done a will that made so much sense on paper. You know, he had, I think it was 3 children. One child had really cared for him, done a lot of work to like really, really care for him in his illness. And he wanted to benefit that child. So he gave that child the house and then said, everything else can be split amongst the kids equally. So it actually looked like a really fair will, considering that that one child should potentially get more. The problem was, and I don't know if the lawyer didn't ask the questions or the client didn't answer them properly, but they didn't have a meeting of the minds. And it turned out that that property was encumbered with so much debt that he required getting every other one of his assets, that the child, to get the property, had to pay off all the other debt in order to get the house. And he also had some life insurance where the other 2 kids were named. So they got a big chunk of money, free and clear, outside of the estate, and the other child, who was supposed to get more, really got an extra amount of debt. So what I like to tell people is, if you retain me to do this, I'm going to send you a questionnaire. You're going to look at that and say, holy smokes, that is a nosy, nosy woman. She wants to know a lot about me. And why does she need to know so much? And I am nosy, I will admit, but I'm nosy for a good reason. This is a principle where it's a garbage in, garbage out exercise. If I don't ask the right questions and I don't get that right information from you, it doesn't matter if I set up the world's greatest plan, because it might not work. I need to know everything about where you hold your money, who the named beneficiaries are, you know, who all your children are. I've had people, you know, not tell me, for example, that one of their children is not really theirs, but someone that they consider to be their child. So they're just giving me this list and I'm saying, okay, yeah, we'll just, you know, we'll leave this to your children. And then somewhere down the meeting, I'll learn that one of them's not their biologic child at all. And that requires we use different language. We need to indicate in that will that, you know, Eric is not my son, but I want to treat Eric as though he's my son. So when I use the word child, I mean Eric. And when I use the word grandchild, I mean Eric's children, right? So you need to be really careful. And in order for your will to be fulfilled the way that you want, the lawyer needs to ask the right questions. You need to give the answers. And then we need to make sure that that plan will really work. Okay, so I am not procrastinating anymore. I'm going to call the lawyer. What are the things I have to think about? Well, first of all, who's going to be in charge? This is probably the number one thing. We want someone trustworthy, not a procrastinator. Someone who's good at getting along with others, doesn't, you know, not the one who causes the fights in the group, but the one who resolves them is usually the better person. And especially if I'm a business owner, if I have a complex estate, maybe someone with some business acumen and knowledge, okay? That's who I really want to be picking. That person will then be in charge. They're in charge right from who can apply for a certificate of death at the funeral home, who gets to decide what happens with my ashes, or if I'm going to be buried, if I'm going to be cremated or not. Those things are decided by that executor, okay? So it's a very important thing that you are appointing. How do I want my money to be distributed? And there's certain things that we can think about in that. So are there people in my life that I just want to give money outright to? That's pretty easy. But are there people in my life who maybe I don't want to have the money outright? So that can be children, not necessarily under 18. It can be up to whatever age you feel they're able to manage the inheritance. We can put it in a trust that says, okay, until this age, the money is going to be used only for these purposes, and a trustee will monitor it. We might have children with a disability or other people in our life who have a disability where we need to create a trust, both for their protection, but also perhaps to prevent them from losing benefits. So if we have a sibling or a child on AISH, we want to avoid giving them an inheritance outright, because then they're not going to qualify for their AISH. But if we can do appropriate planning, we can put it in a trust, and the trust will not impact their ability to get those disability benefits. Spousal trusts. Sometimes we have one relationship that we were in. We may have reason that we want to protect that spouse, but we have children from a different relationship or something. And so we want to be in a situation where we can say, okay, my spouse or my partner can use this money for his or her lifetime, but after that, I want it to go to my siblings or to my children or whoever that is. We can create that kind of trust as well. What do we want to do about our business? What do we want to do about our things? Unfortunately, small things, sentimental items, can really throw a plan off early because people will fight about the things that you wouldn't expect. And so what I like to do and what our firm does, I think a really good job of, is making sure that we leave a detailed plan as to what to do with personal assets. And I like to direct. Again, I'm kind of bossy, so I like to direct what's going to happen. So it might say, I'll leave a list. If I left a list of my items, follow that. If not, then you, group of 8 people, you're the important 8 people in my life. You decide what you want. And if 3 of you want something, we're going to put your names in a hat and we're going to draw a name out. If only 1 of you wants it, it's yours. That can be a really good way to resolve problems. If I, as the testator, set that out, there's usually less argument. But if I've appointed Kim as my executor, and Kim has to make those decisions, and she suggests, well, let's just put the names in a hat. People tend to think, well, that's dumb. I don't agree with that. So then we have a dispute about, well, what if 3 people want, grandma's artwork on the wall? 3 people want the quilt that grandma made. Well, how are we going to resolve that? How do we resolve it without hurt feelings? And how do we resolve it often when the executor, him or herself, probably wants some of these things? So something that's neutral, like taking the names out of a hat or choosing in birth order, tends to work quite well. Funeral instructions also can be put in a will, and it can be really important because the question of what kind of service, whether that service is in a church or not, can be very triggering for the person doing the will, for their family members. Sometimes family have different traditions than the person would have followed him or herself. Whether you want to be buried or cremated, those things can be set out right in your will. And I like to be as specific as possible on the stuff that really matters. So for example, if it's really important that you be buried in a particular faith according to certain traditions, let's say that. If it's important that you not be buried in that particular faith and traditions, let's say that. Because religion is something that is often not shared amongst an entire family or group of people. So there can be some differences there that are pretty specific, and funerals are one of those areas where those really come out to play. We can also look at charitable gifts. So one thing that you can do in your will is to give to causes that you're passionate about. You can identify a charity as a beneficiary in your will. And so it's important to look at that, and it's important to know that there can be some tax advantages for your estate in doing that. So that's something that you should discuss with a lawyer when you're doing your preparation of your documents. If you've lent money to anyone, particularly common is gifts to children, it's important that we document that in our will, because one of the greatest fights that happen is between, especially adult children after mom or dad has died. Sorry. And the question is, well, was I supposed to pay that back, or was it a gift? And, the kids who are feeling like they didn't get the gift will think that it was a loan, and the person who got it will think it's a gift, and now we have a fight. So it's a good idea to be clear about that. And if you do or don't want your executor to equalize that, to call that money in, then we can give that direction right in the will, and that can help alleviate, again, some fights. Now, really important to understand that in Alberta, we have a lot of autonomy in doing a will. The law really respects my right to choose who my executor is, to choose who I want to give my property to. And there are very few exceptions to when the court will actually interfere with my choices. As a contrast, in British Columbia, as an example of a difference, in BC, adult children, well, actually any children, but adult children who have no form of disability, but who just think mom or dad was unfair, can challenge a will. Okay, I didn't get the same as my brother got, or I didn't get anything and I'm mad. Here, if I get a call and someone says, hey, my mom left me out, I'm going to say, well, that was kind of her choice. If she wanted to leave everything to the Humane Society, that's her call. Okay. Now there are some exceptions to that. So in Alberta, we have, of course, our spouses. We have a category that's called, instead of common law partners, we call them adult interdependent partners. And those are people that you're in a relationship of interdependence for 3 years or longer, or shorter if there's a child of the relationship, or with whom you've agreed in writing to be in an AIP relationship, AIP relationship. So our spouses, AIPs, AIP, all have a right to benefit from our estate. We have an obligation to support those people. So if I were to leave my husband out and say he gets nothing, he would have the right and ability to challenge that, okay? If I were to leave my brother out, he doesn't have any remedy. I can decide that. Children who are minors, or you are required to support, and children who are up to age 22 going to university, you are required to support. And then adult children who have a disability that prevents them from earning a livelihood. So that can be a really important thing that we need to talk to a lawyer about when preparing our estate plan. Who are my dependents? Do I have an obligation to support any one or the other? And what does it look like if I do? It may be that you can support a disabled child by giving them an equal share with their siblings. But if my estate is not very large and the person's needs are very great, I may need to consider giving them a greater share of my estate. And that's something that can be discussed with the lawyer in preparing your plan. All right, what happens if we do not have a will? I touched on this. Someone has to apply to be the administrator, so that's in the place of an executor, and there's a list in order. So a spouse is first, an adult and independent partner, children, parents, siblings, they all kind of go down in this list. But again, they may not be the people we would have chosen. So we want to, especially if that's not the case for us, we want to make sure we do a will that appoints somebody. And then the property gets divided according to what it says in the Wills and Succession Act. And if I am married, everything goes to my spouse. If I'm married and I have children who are the children of my spouse, then everything goes to the spouse. If I am married and I have children from a different relationship, then there's a division that happens for my estate. And then if I'm not married, I'm not in an adult interdependent relationship, then we look at, are your parents still alive? If your parents are not, what about your siblings? What about nieces and nephews? So the law will always find somebody that the law deems to be your next of kin. But if that's not who you would choose, it's your responsibility to correct that by doing a will. All right. I see a few questions in the chat. I can't see them while I'm talking, so I will look. But that's it for my prepared version of my talk here. What I'd like to request that everybody do is, not to procrastinate, to sit down and say, okay, I really need to tackle this. And that can mean one of two things. It might mean you're completely at the start and you need to, say, okay, I've never done this. And I would tell you that it doesn't really matter what age you are. 18-year-olds and 70-year-olds equally have the obligation to try to look at doing this for themselves. It's not something that we just really need to look at a certain age. So we need to get it started right away. You need to choose someone who does this, okay? One of the unique things about the career in law is that I am a lawyer. I can do what I want. I could go run a criminal trial tomorrow. I wouldn't recommend it to the person because you'd probably end up in jail. I don't know how to do it. And the same goes for any other kind of law. Find somebody who does this, who doesn't do a will, once a year or something, but someone who does this regularly, because the laws change. Cases come out that we need to be aware of. And you want somebody who's doing this regularly. Think about that garbage in, garbage out principle that I said, and understand that if the lawyer is asking you questions, there's a good reason that you need to answer them. And if you don't know why, ask. This should be a back and forth. You should have a discussion. You should, not like having to go to see a lawyer. Nobody does. I don't want to see anything either, but you like the person well enough to spend a few minutes with them to want to have your questions answered. I am happy for you to email us and we can send you a questionnaire and get started. But really it's just a matter of let's get this done because it's really important. I'm going to leave that screen up so people have my emails, and then oh goodness, I didn't see this chart. So you guys couldn't see anything this whole time.
Well, we could see just that opening slide. So what I would ask.
Oh my goodness.
what I would ask you is it possible to share the slides with us
It
afterwards?
sure is. It sure is. I will email, and everyone can have a copy of it. So
Yeah.
you can't see this now. That's so strange.
Well, we just saw the first title page, and so sorry, there must have been something going on. Didn't want to interrupt you, but
no problem. I will tell you, I pretty much said everything. You missed my pretty pictures about happy families and sad families, but otherwise, yeah, I basically said everything. I am going to stop my share, but I'm gonna try to share my screen on the last page, so you guys can get my email. I think that would be important. So can you guys see that page now with my email? Okay, so I will put that up for a moment, and then if anyone has questions, I'm happy to answer them.
Yes. So while if anybody does have questions, first of all, Erin, thank you so much for this. And I have to say the detail and preparation, I'm OCD, but you really need somebody who's even more OCD than I am. When my partner died several years ago, we thought we had everything in place, but there were a few complications.
Yeah.
And had we been a little bit more thorough, life would have been, I mean, there was no dispute among the families. It was just some complications that came up. So the idea of, it's a fool has himself as a lawyer, or some expression like that. But anyways, I'll stop talking because I see Jan has her hand up. Jan, what is your question?
Hi, Erin. I was wondering if there are any issues specifically related to LGBTQ2S+ people that we should be aware of when we do our powers of attorney or our personal directives or our wills.
Yeah, I mean, I didn't address them because there's nothing that's really specific. I mean, the laws have evolved in a way that there's some protection, but it's a matter of just picking, right? So none of the laws would operate in a different way, but I think it can be important maybe in how we name people. It's probably less important, Jan, the more you have acceptance by your family as to what your relationships are and who's important in your life. But if we do not have that, then it can be really important to make sure that people are given the designation in the documents that is meant for them. So if someone is your partner for life, if someone is your loved one, we want to name that. I've seen too many documents that will say my friend, and then that can be interpreted by people who don't want to recognize a certain relationship, and that goes to all relationships, not just this community. But if someone is your friend, they're your friend. If someone is your loved one, they're your loved one. If they're your spouse, they're your partner, you need to name them as such. And I think as long as we do that, and as long as we do the documents, we can avoid the problems that will happen. Because if I do a personal directive and I name my partner as my agent, the law does not worry about whether that is a same-sex relationship or not. We don't worry about whether that person is transitioning gender or not. Like, those things aren't relevant. What's relevant is who is appointed. Now, one thing that does come to mind as I say that is names can be important, right? If we're thinking about people transitioning and they have names that are important to them to have reflected in documents, we should make sure that we're careful about that. We're also careful, though, about capturing whatever any legal name might be. So, for example, I have a niece who has let us know that she is female, and so she is that's the way it is now. So we do have to go back and say, okay, well, what did mom and dad's documents look like, and do those need to be changed? The law would still allow us to advance to her what was owed to her, but it'd be confusing. So I think out of respect, we want to make sure we use right names. We want to refer to people in the right way, but the laws, thankfully, at least in this regard, have advanced enough that there aren't any additional barriers. There's just the right way to go about saying things. Does that help, Jen?
Yes.
Yeah, and the reason I mentioned the question earlier about, the comment earlier about families by choice was when I was asked to give this presentation, that was something that had come up. that people, sometimes have had acceptance issues with their family or some of their family. And so they want to recognize that, it may be Larry who I really trust, even though Larry is not, family to me, but I want Larry to be included. And so the reality is that the documents allow us to do that. I get to pick. It's power. So what we do need to be aware of, though, is if we don't do the documents, whether you're in a LGBTQ relationship or you're not, you don't get to pick. If you don't do the documents, you get stuck with who the law says is your family. And the adult interdependent partner tag, it's a mouthful. It's overly complicated, probably for some political reasons when it came out. But it can create issues because it's not a defined relationship. So if I'm in a relationship of permanence, of some permanence, it can be nice to make sure I define that in my documents. Like, so if instead of being legally married, my husband was my adult interdependent partner, I would want to label him as my spouse or my partner, or say he's my adult interdependent partner in the document. Because what we don't want is family members saying, I really don't think, Jan's partner is Jan's partner. I think that's a passing relationship. I don't think it's permanent. So we want to make sure we use the terms that matter to us, because rights do flow from those terms. So, that really relates more to a shorter relationship. I mean, if everyone in your family accepts, that Michael's always been part of your life, that's fine. But if you've got people who don't accept that, it's the most powerful thing you can do is name them as such in your documents.
Thank you very much, Erin. Michael, I see you have your hand up for a question. If you, we're getting close to the hour, so if you could be brief, that would be appreciated. Michael?
Yes, first of all, I want to say thank you. And I appreciate the garbage in, garbage out. I mean, I've dealt with a lawyer on that, and you're right, who wanted to know lots of stuff, kind of thing. That my question is, and I also have power of attorney, and I also have persons who would oversee the will kind of thing, and they have a copy of the will and a letter that I also submitted. If I wanted to add something to how the property, what would happen with property in the estate that they would take care of. If I do that with the letter that I sign and they sign and attach it, because it's particularly if it's something that isn't going to change dramatically the will, but I have something that has some sentimental value for one person. I want to just put that in writing, attach it to it, and give it to those folks. Whether you think that would be enough, or do you think I'm going to need to go further?
It's a really good question. I'll divide it up a little bit, because I think it will reflect differently for different people. Generally speaking, if you want to make a change to a will, you cannot just write something on a side piece of paper and attach it. So that won't be effective. What you can do is a codicil, and that is a small change that says, I confirm my will, but I'm changing paragraph 4 and I'm replacing it with this new paragraph. A codicil, though, is only effective if it is signed and witnessed properly, the same as a will. So you need to be in front of 2 witnesses who are both in the same room with you at the time that is signed, okay? What you're talking about, though, in terms of a smaller item, I would say take a look closely at the will that you've done, because most wills, the ones that I do, for example, will say, with respect to property, like personal property, I may leave a list and I ask my executor to follow my list. And if that was the case, and we're talking about, say, a watch that you want to give to a niece or something, you could say, leave a list with your will. You can inform the executor, but you could say, I want to leave the following property. My grandma, 10 kids, I don't know, 50 of us grandkids, and she had a little scribbler, and we all knew where it was. And she would just put notes and say, hey, Erin mentioned one day she liked grandpa's, bowl. Erin gets that. And that was good enough. That was a list. But the will reference that's maybe how that would be done. That's different than if, for example, I want to say, well, I did appoint Jan to be my executor, but I want to change that. Or I wanted to have Lawrence and Bill be beneficiaries 50-50, but now I want it to be 30-70. Those have to be done more formally, if that helps.
Thank you very
Yes,
much, Erin. Jan, do you have a brief comment before we wind up?
Just a quick question. Is my power of attorney or my personal directive effective outside of Alberta, outside of Canada? Yes?
Yeah, so generally speaking, the documents that you do here can be brought other places. Specifically in Canada, we have legislation that says as long as the document meets the requirements, the basic requirements of the province you're trying to use it in, it is effective. So the Alberta one will be good in most places. I don't think you'd have any trouble. It's always good though, if you're moving somewhere, speak with a lawyer there and say, is there some changes I need to make? Often no, but it's a good question to ask if you're moving somewhere.
Thank you.
Thank you very much. And Erin was kind enough to leave her email address with us, and we will also be sending out a copy of her slides. Thank you very much, Erin.
I'm so sorry that didn't work.
No,
hopefully you at least got to see something.
Listen, I was just so intensely focused on what you were saying, and so many things resonated so much for me. So thank you so much. I will say that everybody here will be getting a copy of a survey. Please fill it out. And thank you very much, Erin, for this.
Thank you.
If you have time, if you could sign back on for a quick debrief after this, but if
Sure.
not, we'd just like your input on how this thing went.
Yeah.
The last thing is, oh yes, our speaker next week will be me. I'll be talking about Finance 101 for seniors, some of the things that you should know, dealing with pensions, taxes, credit, that sort of thing. Hopefully you can share this information among other folks that you know, maybe those that are approaching retirement age. I think I've covered off most of the basis of what I was supposed to do. But again, thank you so much, Erin. Really appreciate it. If somebody does have questions, please do send them directly to her. And I think that's about it. Thank you, everybody. We will see you next week. Okay.
Bye.
Bye-bye.